Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. Today I'm going to talk to you about the concept of being trauma-informed. This is a relatively new phenomena in Canadian law and Canadian courts, and so I'm going to talk a little bit about what it means, if it means anything. Does it have any legal effect on what I anticipate the proceedings will entail in the Mass Casualty Commission? Or is it just some sort of commitment to have mental health professionals on site? Or could it be used perhaps as an excuse to avoid hard evidence in the mass casualty proceedings? So when the Mass Casualty Commission was called, there's a legal document that gets signed by both the federal and provincial governments called an order in council. And this is an order in cabinet which officially establishes the inquiry. And this one gives the commissioners of the Mass Casualty Commission 7 directions. One is to start the inquiry. The second is to look at certain issues, and there's the list of issues. A third sets out that they should set out their recommendations and lessons learned, so in other words, write a report. The fourth thing is to have deadlines. The fifth thing they're instructed to do is to be guided by restorative principles and to be trauma-informed. Come back to that. The sixth is gives them authority to adopt procedures as they see fit, and then the seventh is that they will have no expressions of liability in their findings. So I want to talk to you about that fifth one, and the section reads, section E sub I, is that the commissioners are to be guided by restorative principles in order to do no further harm, be trauma-informed, and be attentive to the needs of and impacts on those most directly affected and harmed. Right? So that's from both the provincial and federal orders in council. And also the Mass Casualty Commission lists as a key term trauma-informed approach. And what they say about it is that it's an approach to minimize the potential for further harm and re-traumatization, and to enhance safety, control, and resilience. For example, that is why the Commission does not refer to the perpetrator by name. So that's how they define at the Commission the concept of trauma-informed. So what does it mean, and does it have any legal effect? Is it meant to? Well, the first part is the restorative justice side of it, which is a still developing but really increasingly familiar concept in Canadian law, particularly in Canadian criminal law. And it emerges from the Aboriginal concepts of justice. It's to be inclusive, deals with relationships. It's restorative justice. It's meant to restore both the person, the perpetrator, and also the relationship between either the perpetrator and the victim or the perpetrator and society. And Dalhousie Law School actually has been a leader in this nationally and internationally, including in particular Professor Jennifer Llewellyn. And Professor Llewellyn was involved in the most recent example of an inquiry that was explicitly a restorative inquiry, and that was the Nova Scotia Home for Colored Children restorative inquiry. And so when you look back at this inquiry, it brings some clarity to what it may mean for the Mass Casualty Commission to be guided by restorative principles. Now in the Home for Colored Children inquiry, they had meetings rather than hearings, and they looked to examine the wider context of the situation they were in, the racism and other things that were factors, rather than look to specific actions. Now in that case, there had been many years of litigation and some of the facts were already known, so they had sort of gone beyond part of what the Mass Casualty Commission is going to be addressing. And they looked to, in the restorative inquiry, looked to strengthen relationships and build community capacity through collaborative processes, rather than having the commissioners deliver a report to government. It was a collaborative report, a collaborative process throughout in the other case. In the Mass Casualty Commission and many other judicial inquiries, you have a commissioner appointed who writes on their own, makes determinations and recommendations to government on new or updated policies for public agencies. So, restorative does mean something. We have in the Mass Casualty Commission mandate that they're future-oriented. They're not to make findings of liability. They are to lay out lessons and lay out recommendations. So, in a way, that sounds very much like a restorative process where they would also be looking for recommendations and looking to the future for things that could be done better. Well, it's kind of like the Marshall McLuhan quote, "The medium is the message." In part, the process is the outcome. In the Nova Scotia Home for Coloured Children restorative inquiry, the fact of collaboration, the meetings that were ongoing among stakeholders, that process itself was part of the outcome. And so I think part of the hope of the Mass Casualty Commission is that through the process of roundtable discussions, other meetings, community meetings, that in itself will have some kind of an impact. People working together and having some stand-up conversations. And I would say, really, if there's any hope to reestablish the trust between the community at large, the communities, and the police, then it would likely be through this sort of process. And I would go a step further even to say that it is the police should really be embracing this opportunity and this approach and taking advantage of that to try to regain some trust in the communities where they've lost it. So, it's a good approach for certain things like dealing with, how police training works for domestic violence calls, how, police are trained in communications, these sorts of things. It's not so good for issues of what happened, dealing with the hard evidence, the facts, contested, concealed evidence. Really needs to be exposed through a precise and adversarial approach that you can really only get through a traditional form of cross-examination. So for the first part of the Mass Casualty Commission hearings, we're certainly going to need to see a more traditional court-like approach of witnesses being cross-examined, get to the facts. Now, there's been no promise or confirmation from the Mass Casualty Commission that is actually going to be the case and that they're going to follow that kind of a procedure, but I'd be very surprised if they didn't, and I would suggest even that there would be a backlash if that wasn't part of the initial phase of the Mass Casualty Commission hearings. But that brings us to the second key part of that directive to the commissioners. First, take restorative principles and employ them, but then to be trauma-informed. Now, this is, like I said, a relatively new phenomenon in Canadian courts. It really has, there's been witness aids and other things in courts, but to use the term trauma-informed is something new. There's been journal articles on it, but it hasn't been judicially considered, from what I could find in my research. But broadly speaking, really what it is to be aware of specific ways that people experience trauma and to develop policies and practices that are reflective of that understanding. They could be flexible and specific. So, for example, if somebody has anxiety, well, they can testify from behind a screen. If they don't want to see a group of people in front of them, 50 people watching them testify, well, they could be in a different room. They could have a support person with them and still give the best evidence. It helps everybody because it allows the witness to be comfortable, and when you're more comfortable, then you're able to gather your thoughts a little more easily and present that evidence in a more coherent fashion. Now, the other things that they can do is, have, a support person or a lawyer with the person in a different room. In the Desmond inquiry, there were things like the photos of the scene weren't broadcast on the live stream. If it's not relevant to some issue that the commissioners need to determine, then there's no reason to put up photos that are just going to upset people. The same with the 911 calls. In the Desmond inquiry, there was certainly no relevance to the initial 911 call to any of the issues that were going to be determined. That may be not 100% the case in the Mass Casualty Commission hearings. I understand there's a long 911 call. I've heard part of it from the children that were hiding in the basement in Portapique at the Macaulay home. That probably won't need to be played. So TraumaInformed would say, well, we get a transcript of that call for the relevant portions that are needed, just the time of the call, some of the content of it to, establish what the police knew or should have known at that time. Maybe explain why those children weren't rescued immediately instead of having to wait for some time. So that sort of thing. But that can be done without playing the audio itself. You can have a transcript that's available. So that's a trauma-informed approach. In the Desmond inquiry, they also had separate rooms for the family where they could go during the hearings. They could watch from there instead of having to be in the courtroom itself. And victim services staff on hand just to take care of any needs the person may have and just be there to someone have to talk to if they needed somebody else. So, but what it's not, trauma-informed is not an excuse to avoid hard evidence. We're talking about the murders of 22 people, and you can't have a meaningful discussion about something like that without getting into some difficult emotional territory. And being trauma-informed isn't a way to avoid difficult topics. It's a way to talk about difficult subjects without exacerbating the trauma and the traumatic experiences that have already gone on, and to allow participation by those people whose voices we need to hear and who otherwise may not feel comfortable testifying in court or in an inquiry setting. So it's a way to get a more fulsome understanding without without re-traumatizing people, or to do it in a way that's most sensitive given the very difficult circumstances. So that's what I wanted to talk about. It was it's something that is really foundational to the Mass Casualty Commission proceedings. It's the approach that the governments have told the commissioners to take to the evidence and to the participants. So I just wanted to explain what legal effects that may have. Really, it should be minimal in terms of the effect that it has on evidence that is received and the ability of the commissioners to make a solid analysis of that evidence and come up with good recommendations afterwards. So I hope that was illuminating to some extent, and people enjoyed hearing that. If you have any comments, please feel free to make them. Share and like, share with a friend if you think anybody else might be interested in these videos, and I'll certainly keep making them and keep bringing other things to your attention. So thanks for watching and listening, and we'll see you next time.